Good evening, everyone. Welcome to today's LawWorks Legal Primer webinar titled The New Copyright Act 2021, Changes that Affect You, organized by the Law Society Pro Bono Services in collaboration with the National Trades Union Congress and in partnership with the Intellectual Property Office of Singapore. I am Kay, your moderator for today. Just some housekeeping matters before we get started. First, please do not take any screenshots or share the materials here without the permission of the organizers. Second, please feel free to ask questions at any time during the webinar using the Q&A function. We will do our best to address your questions during or at the end of the talk. Third, please note that our discussion and any materials provided are not intended to substitute or constitute professional legal advice. And of course, finally, you should consult a lawyer if you require specific legal advice. All right, with that done, let's get right into the discussion. The use of digital and online platforms in the arts have become prevalent, more so in recent times when COVID-19 has affected not just all of us in the arts, but everyone in this interconnected world in one way or another. Changes to the law and amendments to the new Copyright Act have been passed in Parliament, some of which will be helpful as we settle into this post-pandemic world. Have you had your intellectual properties misused or even stolen before? How does this new Copyright Act take into account the increasing appetite for the arts to be produced and consumed digitally? How does this new Copyright Act benefit both creators and users? Let's dive into how we successfully navigate the topic of intellectual property in the digital world. We're very honored to have three distinguished speakers share more about this topic today. First, we have Ms. Trina Ha. Trina is the Chief Legal Counsel and Director of the Legal Department at IPOS. Next, we have Dr. Stanley Lai, SC. Stanley is a partner at Allen & Gledhill. He is also the head of intellectual property practice and co-head of the Cybersecurity and Data Protection Practice. Speaking alongside them is Mr. Patrick Tay. Patrick is the Assistant Secretary General of NTUC and Director of NTUC's Legal Services and Strategy Division. Their full bios can be obtained via the resource link available during the panel discussion later. Trina, Stanley, and Patrick, thank you for joining us today. We'll start today's discussion with Trina sharing a presentation on the new Copyright Act 2021 and two key changes you should be aware of, as well as the basics of copyright law. We will then hear from Stanley, who will cover common case scenarios which some of you may find yourselves in. Patrick will also then join us to share his practical insights and help available for creative professionals who are navigating the realm of safeguarding their intellectual property. We'll end the webinar with a Q&A session where Trina, Stanley, and Patrick will aim to answer any questions you have. As mentioned earlier, please feel free to ask questions anytime during the webinar using the chat function, even if it's before the Q&A session. We'll do our best to address them during the talk or at the Q&A session. Without further ado, I'll pass the time to Trina and Stanley to share about the new Copyright Act now. Trina and Stanley, the floor is yours.
Thank you, Kay, for the kind introduction. And good evening, everyone. I'm very pleased to be here. I'd like to thank NTUC and the Law Society Pro Bono Services for organizing this webinar and inviting me to share with all of you on a new Copyright Act that will come into force in the later half of November this year. Next, please. So let me start off by giving you some background to this new Copyright Act. It is a culmination of the most extensive review of the original statute, which was enacted back in 1987. This review is conducted by the Ministry of Law and IPOS on how technological and market developments have significantly impacted copyright law. Now, the review started way back in 2016 with our first public consultation, seeking views on 16 proposals. The exercise has been very extensive with multiple public engagements over the years on different issues. Now, in terms of the legislation itself, the new act is a complete rewrite of the existing statute It has a new and hopefully more intuitive structure, and it uses plain English to aid understanding by everyone. Now, I need to say here that this is not a final review. The law has constantly evolved to take into account changing business norms and technological advancements. We will continue to review our regime and take on feedback from our stakeholders, guided by the key principle of ensuring that rights are reasonably clear and efficiently transacted. Next. You will see on screen here a snapshot of the different rights and the different changes under the new Copyright Act. These changes generally fall within 3 buckets that benefit a whole range of players in the ecosystem. There are new rights and remedies for creators and performers. There are new exceptions to ensure works are reasonably available for societal benefit and supporting innovation. They range from computational data analysis, use of works, to new exceptions for galleries, libraries, archives, and museums to aid in their mission of preserving our cultural and historical heritage. And there are also changes to strengthen the ecosystem. One such change is a new licensing regime for collective management organizations, called CMOs for short. Now, this will not come into force at around November this year. We hope to bring it into force next year, but we will first consult on the proposed license terms with the public. And so you will see here that we are seeking a balance between the different groups of stakeholders, their interests and benefits, and all for the purpose of updating copyright for the digital age. Next, please. Before I go into the key changes that impact you, let's go through some basic copyright principles. Next. So what exactly is copyright? It is actually the right of the owner to prevent the unauthorized use of the tangible form in which you have chosen to express your idea, whether it's a book, a musical composition, a song, or a film. And it is important to note that copyright protects the form of the idea. It does not protect the idea itself. So there is no need for the work to be new or novel. It needs to be original in the sense that it is independently created by that person. So that's why the Romeo and Juliet theme is evergreen. You see it in so many forms and iterations on so many different platforms, as well as recently, we have been seeing a lot of versions of the theme of girl meets and falls in love with a vampire, as you see on the photo on screen. And definitely artistic merit is not a requirement for copyright protection. So in Singapore, copyright law is governed by the Copyright Act, but is supplemented by decisions of the court, what we call case law, on how the law should be interpreted and applied to factual situations. Next. You see on screen a list of the different types of works that are protected by copyright, including performances. And as you look at this list of works and the examples that I have on screen, I think you will start to see that a lot of the content and products that we consume and use actually comprise of multiple layers of copyright works. I'll give you an example of a CD of songs by an artist. Now, the CD itself is protected as a sound recording, and in it are songs which actually comprise of 2 types of copyright works. You have the lyrics, which are literary works. You have the melody, which are musical compositions. And then you move on to the packaging of the CD itself. The cover of the CD would likely contain artistic works because it could have a drawing, an illustration, even photographs of the artist, and those are also artistic works. So one product, many types of copyright works in it, and they're all independently protected. And so what are the rights that a copyright owner has? Next, please. Here, you will see on screen, in a nutshell, it's exclusive rights to do, authorize, or restrict reproduction of the work in various forms, adaptation, which includes translation, communication of the work to the public, which includes broadcast as well as internet transmission, and to perform the work publicly. Now, under the new Copyright Act, there is a new right of equitable remuneration to owners of sound recordings. They now have a right to collect payment when their sound recordings are performed in public, and this right will be administered by the collective management organization called Music Rights Singapore, or MRSS for short. Now, Stanley later will talk more on copyright law in terms of infringement, defenses, and remedies. So next, please, I will be moving on to the two key changes that affect you as a creator or performer. Let's move on to the first one. The two key changes are the change in default ownership of copyright of certain works, as well as a new right for creators and performers to be identified whenever their works and performances are publicly used. So we'll move on to the first change. All right. So under our current copyright law, content creators are the default copyright owners. And there are two exceptions. The first is for commissioned photographs, portraits, engraving, sound recordings, or films, the commissioning party is the default copyright owner. And in an employee-employer situation, the employer is the default copyright owner only of literary, dramatic, musical, and artistic works created by the employees. So you'll see there is some uneven treatment in copyright ownership depending on the type of works. And this is really a historical version dating decades back to even before the Copyright Act came into force in 1987. But technology has changed so much since then. And the prevalence of social media, smartphones, easily accessible technologies have greatly changed the way in which creators operate, how works are created, even what works an employee is able to create. So as such, there is a need to standardize these copyright ownership positions and bring us in line with international norms. So under the new Copyright Act, content creators are the default copyright owners for all types of commissioned content. And for employee-created content, the employer is the default copyright owner of all types of content created by the employees, as long as it's done in the course of their employment. Next, please. Now, these are called default positions, which mean they apply if the contract is silent on who is the copyright owner. But parties can agree in writing to reverse the default position such that the commissioner owns the copyright. Now, the changes in the Copyright Act are prospective, meaning that even if they only apply to works created after the Act comes into force in late November. Even if you had signed a commissioning contract on, let's say, 12 November, but the work is created after the Act comes into force in the end, towards the end of November, the new law would then apply. But if you created the work before the Act comes into force, then the old position will apply. And we also need to remember that other laws continue to apply. We can't just look at copyright because there are laws that are applicable, like defamation. How have you used the illustrations or the photographs of people in a way that defame them? Criminal laws, you may not use works or photos of people to blackmail, for instance. And we also need to consider personal data protection law. Now, let me give you an example. Under the Personal Data Protection Act, photographs that feature individuals, like family portraits, wedding photos, graduation photos, essentially portrait photography, this actually constitute personal data. And as such, this means that even you as a photographer, if you own the copyright to the photographs, it does not mean that you can do what you wish with these photographs, because for personal data, you need to obtain the consent from the individual as to how you may use it. And consent can also be withdrawn. So let's take the example of a family portrait. And under the terms of contract of the photography studio, the copyright belongs to the photography studio. But it doesn't mean that they can put the photos online, distribute it to their clients. They need consent of the family members featured in those photos. Right? Next, please. But what does this mean for you as a creator? Well, if the commissioning contract is silent on copyright, you, the creator, will own the copyright. It means you're less likely to inadvertently lose your rights because you were not aware of the law or you forgot to put in the term of copyright ownership. But it is still good business practice, and we highly recommend that you put things down in writing. Not just who owns the copyright, but also what rights does the client have in the work, how they may use the work. And also, very importantly, what rights do you have, especially if you agree to assign away, assign meaning to transfer, to sell your copyright ownership, could you still have rights to the work? If you wish to have rights to the work, you need to retain them in writing. And some of these rights could be to include the photos in your commercial portfolio, to put them on your website for marketing purposes, or even to submit it for exhibitions or a competition. So it is important to be very clear in writing who may do what with the commission work. Right. Let's move on to the next change, which is a new right of creators and performers to be identified. Under our current Copyright Act, creators and performers only have a right to prevent false attribution, meaning that they can stop somebody from falsely attributing somebody else as the creator of the work or the performer. But there is no independent right to say, hey, you need to credit me as the creator of the work. But this has to change because we live in a digital age. Copyright content and performances are more easily distributed, especially on social media. And it is quite common to not even attribute, but simply to retweet, reshare, repost. So it's time to introduce this new right of attribution, a new right to be identified, which is not uncommon. An increasing number of jurisdictions have such similar rights. And we have taken precedence from jurisdictions close to us, like the UK and Australia. So what is this new right? Well, under the new Copyright Act, anyone who uses literary, dramatic, musical, or artistic works or protected performances in public, you must identify the creator or the performer. And such public use could include publishing the work, including reproducing it into your corporate collaterals, even sharing it online. And the identification must be clear and reasonably prominent. Now, this legislation does not dictate what is clear and reasonably prominent. I think this very much depends on the scenario, the type of content, and the manner in which you use it. Next, please. However, like in every type of copyright law, you need to balance, right? I keep talking about balance because that's what it essentially is. How do you protect and strengthen the rights of performers, but not impose an undue burden on users when they want to access the work? So as such, there are certain exceptions where we recognize that you do not need to identify the creator or the performer. Clearly, you do not need to do so when the identity is not known. Where the author or performer has consented to not being identified in a particular circumstance, which they can do so in writing or even verbally, or in the contract of engagement, they waive their right to be identified. This means that they relinquish their right to be identified completely, and such a waiver needs to be in writing. Certain works and performances, the use are exempted, meaning that you do not need to identify for when you use it for purposes such as examinations, if you are featuring an artistic work in public, and there's an incidental inclusion of the work in films or television broadcast or cable program. And of course, there's always fair use for the purpose of reporting news. And there are certain materials that are exempted, such as computer programs, because we have studied this, we have taken feedback from a lot of institutions and companies and enterprises. And similarly, like with the UK, the landing is that there's so much contribution by so many people to coding. A person could just write maybe 2 or 3 lines of code, so it's not practical. So for computer programs, it's exempted material. And of course, works made in the course of employment, which is first owned by the employer. All right, next, please. Now, what does this mean for you as a creator? Well, hopefully it will foster greater respect and recognition for your creative efforts. It will help you gain exposure and build reputation. I have on screen examples where, of users who do not credit the works of others. So the first is the original photograph, and the second is a repost, which does not mention who took the photo. Please remember as a creator that you have to waive your right in writing only, but be careful that when you consent to a specific instance, a verbal consent might be sufficient. Now, if somebody has infringed your right to be identified by failing to do so, you can take action, and remedies include injunctions, such as a court order to take down the work, or even a court order to mandate the user to put in a credit to you, and damages, but only, of course, if you have suffered monetary loss. Now, I would end my segment by talking about how this right to be identified is separate from copyright ownership. The right to be identified is personal to you. You may not transfer it or sell it away. So even if you had given up copyright ownership, whether because you're under an engagement, commissioning, or simply you have sold the content away, you still retain your right to be identified unless you have waived that. So let me go through a very simple scenario. Say you are an illustrator of children's books and you enter a contract with a publisher to create illustrations for a new book. And under the publishing contract, you agree to assign the copyright to the illustrations to the publisher for a nice fee, but you do not waive your rights to be attributed. So when the book is published, you will see your name there illustrated by XX. Now, the book is a success. Somebody reproduces extracts from the book that contains featuring your illustrations and freely posts it online. You do not have the copyright to the illustrations anymore. The publisher can sue for copyright infringement to both the book, the literary work for the text, as well as the illustrations. But you, the illustrator, you can consider a separate cause of action, which is for infringement of your right to be identified because the people who posted it did not identify you. So I hope this example illustrates how this new right will act and interact with copyright. So that brings me to the end of my segment. Thank you very much. And I will now hand over to Stanley, who will talk more about other copyright principles and how do you navigate these changes. Over to you, Stanley.
Thank you very much, Trina, and good evening, ladies and gentlemen. I appreciate NTUC and also Law Society and IPOS as well for the very kind invitation to address you on the new Copyright Act and some of the issues which really we're already seeing as being a matter for question. At the same time, also, I think it's an opportunity to have a discussion with you on any questions that you may have. Next, please. What I hope to do is to outline, not by way of a detailed overview, but what I consider to be some of the important principles in copyright, which I think should apply in our dealings. And then I'll talk a bit about a case study, which is quite typical, certainly amongst the user community, and then share some final thoughts before we launch into a session of Q&A led by our moderator, Kay. Next, please. Next. So in terms of copyright, I mean, you've heard the sterling introduction by Trina, and there's no need to repeat much of that. But I do need to stress a few fundamental precepts about copyright. One is the requirement of originality. And you're really talking about the authorial creation that is causally connected with the engagement of human intellect. That is a very detailed and complicated way of basically saying that, look, it has to originate from you. The provenance must be from you. Copyright typically also protects the expression of ideas as opposed to just ideas in themselves. If you just want to protect ideas, then copyright may not be the law to refer to. It will be the law to refer to if you want to consider different ways of expressing one common idea. So there are numerous plots in storybooks detailing murders and who the identity of the murderer is. All of them may have a very predictable storyline. The butler did it, the house owner did it, but at the end of the day, everybody uses a different form of words. And just by using a different form of words, you may potentially enjoy copyright in your own right because you created what then becomes the original literary work. And original in the sense that it is not copied from any source. So different expression is what counts. The Other requirement also is a stress on human authorship. Now, some of you may be interested to ask the question, well, what happens if monkeys take photographs? Do they get attributed? Well, the US courts have said no. What happens if an artificial intelligence program creates a work? Then who is the author? Singapore law, as it currently stands, and the authority goes back to a case, Asia Pacific Publishing, which I argued in 2011. It does stress and state that human authorship is principally required for the Copyright Act. And that it ties in very nicely to what Trina was talking about in terms of the moral right of attributing the status of author, or to be identified as author. It has to be a human being that enjoys that status. But at the same time, we understand how the Copyright Act evolves into a mixture and a interrelationship between authors' rights and publishers' rights. Every author typically will need a publisher to take his work to market. And what then happens, and what is the copyright that's owned by the publisher versus the author? The author owns the original and the rights to his original literary work. The publisher owns a limited right to basically reduce his work into a typographical published edition format with which he then sells. And that typically is a lower duration, 25 years, whereas the author's copyright lasts for the author's lifetime plus 70 years. Next. And so, of course, we heard Trina talk about exclusive rights, and these are all rights which are basically controlled by the copyright owner. And the right to publish a work is one such right. So as an author of a work, if a publisher wishes to engage you, the publisher actually needs a license from you. So when dealing with publishers, the advice given to many authors would be that resist any suggestion of an assignment of copyright, because once you have an assignment put into place of your author's copyright in favor of the publisher, then guess what? The publisher becomes the new controller and owner of the author's copyright, which potentially gives the publisher perhaps very extensive and disproportionate protection over your work. We also bear in mind the defenses to infringement. And in addition to fair dealing, which I will deal with, and fair use, there are also a number of very specific exceptions. And of course, I can't do justice in a presentation like this to all the defenses that potentially apply, but there are defenses for religious performances, copying on the premises of an educational institution for the purposes of education, sculptures in public places, buildings and models of buildings. These are all very specific categories of established defenses which still find their place in the new act. And of course, there also has been additional expansion, which Trina alluded to, educational uses, for example, by non-profit schools, computational data analysis, when you're doing text and data mining, for example. There are new defenses. And I think for the purposes of today, we obviously can't go through every single one, but just bear in mind that for every infringement, the classic question to ask is, can the defendant avail himself of a defense? And that's something an advisor needs to take you all through as well, so that in addition to just establishing a prima facie case for copyright infringement, there's also a need to see whether a defense can potentially apply, which can be a response. And there are also remedies, injunction, damages, additional damages, statutory damages, account of profits, any number and myriad of remedies that we're used to, that continues. Next. Let me just give you an illustration of an example of why we have to be prepared, as lawyers certainly, to be surprised. And this is a case that was heard in the United Kingdom. I'll just look at the left photograph, which is basically the plaintiff's photograph. The right is the defendant's photograph. Now, those of you who are photographers, you will appreciate certain commonalities, namely in the backdrop, in the use of the iconic double-decker bus, the application of red and black, and I think white letters just for the purposes of the bus, the device of the bus, but at the same time, taken in the same rough vicinity of Westminster with the Houses of Parliament behind and a backdrop of Big Ben. The defendant basically produced this photograph. The plaintiff sued the defendant for infringement in the IP Enterprise Court in UK, and guess what was the result? How many of you actually think that there was an infringement? And you will not be surprised if I were to tell you that, I've taken many surveys with this problem with students I've taught and even occasionally some clients, and they will not think that there was a case for infringement because you're talking about two very different expressions. But guess what? The court found infringement. Next. And that's why we cannot take cases for granted. Because what the court was impressed with was the use of visual contrast features, including angle of shot and field of view, which the plaintiff actually had authored, but also with the aid of computer technology. So what was decisive was considered by the court to constitute arrangements, namely the motive, visual angle, illumination, and so on, selected by the photographer himself or herself. And the court was prepared to find substantial reproduction because the defendant's pictures were not just photographs of cliched London icons. They also included the same visual contrast features against the basic composition of the scene, from which there emerged this combination that made the original image visually interesting. So you can see also that, even those of us who have taken photographs and would be quite prepared to say that, well, you can't actually own the copyright in the scene. In an appropriate factual context, where skill, judgment, and labor is applied to the creation of a certain genre of photograph, if that is copied or somehow misappropriated by another party, the courts may not have any hesitation to find infringement. So my purpose of this example is not so much for shock, but just to alert us to the fact that you can't take anything for granted. And a lot lies behind the creation of the work, whether it is human only, which is usually the norm, or is it with the use of computer-aided design technology? What sort of editing software did you use? What were the creative choices that led to the creation of this visual contrast? This case, Temple Island Collections, may very well be the exception rather than the norm. But the point to make is that the fact that there is an exception or a case like this that is quite robust in terms of the judgment that was issued should give us pause to think, well, we better be very, very clear on our inspirations. Where do we actually think the inspiration for creating a reproduction of a work comes from? So this is a very good example. Next. So we come to a very notable change, which is fair use, fair dealing, and fair dealing under the current Section 35 of the Copyright Act comprises 5 factors to consider. So if you apply these 5 factors to a particular activity, the question then is whether you can be excused of the allegation of copyright infringement. I've deliberately struck out the last factor because under the new Copyright Act, the last factor is no longer a consideration. But for the first 4 factors, you look at the purpose and character of the dealing, the nature of the work or adaptation, the amount and substantiality, and you look at the effect of the dealing on the potential market. Now, the point to be made at the very outset is if you look at the first and the 4th factors, they are very much linked to economic reasons and economic harm. What is the commercial impact on the copyright owner's market for his own works? So that would suggest to be a factor of some importance. And then you balance that against the nature of the work or adaptation. If the work is factual as opposed to completely creative, if it's a very functional, fact-driven type of work, well, obviously fair use that operates in favor of a fair use finding. Similarly, the amount and substantiality of the work you always consider. I mean, the general rule of thumb must be, and I say general because there is an exception. If you take 100% of any work, it's quite difficult to justify that the amount of and substantiality factor actually counts in favor of fair use. The only qualification to that is twofold. One, for certain types of works, like if you're doing a practical criticism and review of poetry, for example, very difficult to exclude all the verses or stanzas of a poem. You're more likely to reproduce the entire poem before you can do a criticism and review. So that may be one example of an exception to the factor on substantiality. The other would be, I mean, for example, if you're creating a lot of offerings that you make available through the internet, sometimes in order to create a search engine or some sort of search index, you may need to make an entire copy of a work first, but the end user never shows it. You have to make an intermediate copy so that you can make an end user product known and seen. So that may be another factor of tolerated use based on the factor. Now, the very important thing to mention about these four factors is that they are non-exhaustive. So you can actually, even I think, you know, in a future case, a court may even look at the fifth factor, even though it's no longer in the statute, and say, well, that's a factor I would also want to consider in deciding for or against fair use. So that's important to bear in mind. The other point to bear in mind is with fair use, you also have other specific defenses like research and study, criticism and review, judicial proceedings. The same four factors have to be applied to these specific fair dealing defenses as well. So under the new act, these other specific provisions are not spared from an evaluation of fair use based on these factors. So let's talk a bit about the fifth factor next. The fifth factor was actually removed because there was a recognition of the change in the current technology landscape. A lot of works are no longer distributed in physical medium. And the last factor may be less relevant in the light of new platforms for content creation and distribution. And also, that consideration can also elide into the fourth factor. So it was, for that reason, that's been removed, and now we have just four factors. Next. So by way of illustration, I mean, this is one, Global Yellow Pages is one case where it went through quite methodically this analysis on the purpose and character of the dealing. And of course, commercial exploitation, if that is the purpose, it is a factor that operates very strongly against a finding of fair use. The nature of the work, which is the second factor, is less likely to be fair in cases involving fiction-based as opposed to fact-based copyright works. We talk about thin and thick protection as well, depending on the functionality or the factual nature of the work versus creative aspects. Next. And the amount of substantiality, as I said, you also weigh that against the reasonableness of assessing that quantity and the value of these materials that were used and for what purpose. Also interrelating to the other factors in the fair use determination. And of course, the effect on the use of the use on the potential market is absolutely key and talks about market harm, because at the end of the day, copyright infringement is a civil wrong and very much turns on the harm to the copyright owner. Next. So I've given some examples of fair use just to give us an inkling of where in cases in the US where fair use has been determined. Recordings made by videotape recorders were held not to infringe on the copyright of television program broadcasts or on public airwaves. They were only time shifting in nature, even though 100% of the work was taken. So that was one case in the US. You also have Wright and Warner Books, Inc., where the biographer quoted 6 unpublished letters and 10 unpublished journal entries by another person But overall, the less than 1% was copied. Similarly, the Authors Guild case, libraries that provided Google with books to scan, and this was part of the Google Print Library project launched many years ago. They were held to be protected by fair use when the libraries later used the resulting digital scans for full text search engine. But you could never get the whole book. The whole idea is you do a search and the engine will basically throw out passages which were not copyright infringing in themselves, but would contain the keywords based on your search. Next. And similarly, the Swatch case, Bloomberg posted a recording and transcript of a phone call made by Swatch to analysts. The overriding purposes was not to scoop Swatch or supplant the corporate owner's commercially valuable right of first publication, but rather simply to deliver newsworthy financial information. So we do see, pretty expensive use of cases of the fair use doctrine in cases like the United States. The caution is that for Singapore, you can't make the same assumption. Cases like Kelly and Aribasoft, for example, where it was held that the creation of thumbnails of images and placing them on search engine results did not undermine the potential market, because thumbnails were smaller, poorer quality, the resolution is inferior than original photos, and therefore you could index them and take the position that this could be a fair use. I think an argument could be made under Singapore law, low-res photographs like thumbnails could arguably come under that categorization. But of course, you could view the use of thumbnails and not just look at thumbnails in themselves, but the context in which they feature in the offering and holistically make the assessment on whether there's a fair dealing. Next. And we also have to bear in mind the importance of parody and transformative use cases. You will see this language coming up more and more. Most common would be the transformative use doctrine, which went to create this new search engine that would provide references to scan text. But that's not before Google made millions of copies of whole books, scanning them and putting them into the book service for searches to be done. And it was held in this case that, look, even though there was an intermediate copy made of the work, the end result and what the users actually saw was not the entire copy of the work that was taken, but a transformative use was made in the sense that extracts were made available for viewing after the search was actually made. Campbell and Acuff Rose is perhaps the seminal work in 1994, where the US Supreme Court basically articulated transformative use. And that was done in the context of a parody where someone used completely rewrote the lyrics to the musical work Pretty Woman, which I'm sure those of us who are old enough will remember, and of the Richard Gere and Julia Roberts fame. But even though you change the words all together and then you create a parody almost, the question was whether it could be a fair use. And the court was quite prepared to find that in the nature of First Amendment provisions in the United States, it's something that they could tolerate. It is essential for someone doing a parody to be able to quote from existing material and use some of the elements of a prior work to create a new one that comments on the original. So this is not Singapore law at the moment, I have to say, but it just shows how the fair use doctrine has been stretched and expanded to different uses in other jurisdictions, more notably the United States. But why we have to draw caution is there's a very strong First Amendment protection underlying the finding of the legitimacy of parody usage, which we all have to bear in mind. And there we have it. Next. So if I was to look at a case study, next, just by way of an illustration, let's look at this. I mean, a company engaged a photographer for an event to take photographs to be used in the company's promotional and marketing material, including its website and corporate collaterals. Company's representative and the photographer negotiated the fee and confirmed other details such as the duration of the event and the number of photographs to be provided to the company via email. The photographer sent over a written quotation, which was accepted by the company. There was no mention in the email or the terms and conditions of the quotation as to the copyright ownership of the photographs. Same company also engaged a viral news platform to write and publish an opinion piece incorporating an interview with the company's CEO as part of the publicity for the event. A journalist interviews the CEO and writes the news piece, which is published on the news platform as well as the company's website. So next. What are the works involved? Who owns the copyright to the works? What can the company do with the photographs and the opinion piece? What can the news platform do with the opinion piece? What can the photographer do with the photographs and formats? What other rights are engaged in this situation? So these are the questions that may typically arise in relation to such a case study. Next. Under the new Copyright Act, the photographer will by default own the copyright to the photographs taken at the event. That must be the starting point, because creators' rights and authorial rights are now elevated to the point where the author, that it's very clear that the author is the owner of copyright, and he will enjoy it as such. And even in the case of a commission work, if he's commissioned by someone to do it, in the absence of any contract to the contrary, he is the first owner of copyright. That is the consequence of this new act, which Trina alluded to. Whilst the company may use photographs for the purposes for which they were commissioned, the photographer, as the copyright owner, may use the photographs for his own purposes, such as for his commercial portfolio. So it's incumbent on the photographer to be able to negotiate and make sure that by way of contract, the company realizes that he is the copyright owner, and that their purposes and their intended usage of this material needs to be with his consent, expressed through the license. So I think that's an important principle to bear in mind. And I think the other point which Trina made, which impressed me, was the fact that if the photographs contain images of persons such that they will be considered personal data, the obligations under the Personal Data Protection Act may also be relevant. That's absolutely true. And I mean, Trina talked about the example of a family portrait, but if you just talk about any engagement, say by a wedding photographer, if he takes 300 photographs of the couple on the day of celebration, but transacts only the best 100 with the couple, the fear always is, well, what does he do with the remaining 200 photographs? Before you even get into the question of whether they are in which digital format, whether they're stored in RAW, JPEG, or some other digital format. Well, I think that the one point that will also be a very heavy and influential check is the fact that the PDPA also has to be respected. So not only are you putting yourself in jeopardy if you would use these photographs in different settings with abandon, because the subject is not you, but you took the photograph. So all things being equal, you're the first owner. But you also have to think about getting consent, because photographs are personal data under the PDPA. It's quite clear, because it's capable of identifying human beings and human subjects. And for that reason, I think the PDPA forms a very great constraint to what use can be made of photographs. So I think initially, when in September or even as early as April this year, there were quite a number of news pieces that talked about how photographers are now going to charge a lot more for engagements and so on. But bear in mind, they may take more photographs than would actually be needed for the engagement. But that's not to say that other laws don't apply, like the PDPA. So get your advice, whether you're the photographer or the subject, get your legal advice accordingly. Next. The opinion piece, it will generally be considered a literary work created in the course of employment. And if it's created in the course of employment, the rules are quite clear now under the new act. It is the employer that owns the copyright. Whereas in the old law, I mean, there were some vagaries there. For example, if you were the creator of a sound recording or a film in the course of your employment, there was some doubt in the previous regime, the previous Copyright Act, that actually the person creating it, that individual, even though he's an employee, would own the work. Now this new act makes everything very clear. The employer actually is the owner for anything created in the course of employment. But more importantly, and developing from what Trina said, was that, you know, regardless of ownership, there's a need to identify the photographer or writer in relation to any public use that's made of works. So in websites, social media posts, and so on, unless this is waived in writing. So if you are dealing with authors, and you may be faced with a position where they may actually be in a position to assert their moral rights, the exceptions don't apply. Think about the context in which this should be set up, because it could very well be that you can negotiate with an author to say, well, we're going to insert the attribution here, but not this part of the work. So I think we can be a bit more creative in which parts we will agree to assert, and subject to that, you get the agreement of the author as well. There may be a way to come to an arrangement so that at the end of the day, the attribution objective is satisfied. And at the same time, you're not seeing the work placed in prominence everywhere. So I think there's a lot of negotiation that has to come through this process, and we're looking forward to it. Next. So in terms of final thoughts, let me just share some final thoughts with you. Next. I think contractual clarity is increasingly important. I think once we know the default rules, and if you're commissioning a work, well, I think the main aim would be to engage the creator of the work in some sort of contractual discussion, because he will still need you to pay him. And the question then is, how would you want to scope the engagement? Very similar to what the current rules are anyway, except that this makes it much clearer in terms of the category and the number, different types of works which can come under this kind of arrangement, for which the person doing the creation is still, by default, the corporate owner. And what you're seeking to do by contract is supplanting that or varying that to a greater or lesser degree. Some exceptions cannot be excluded by contract. That's important to know as well. I mean, there are a lot of provisions that cannot be derogated by contractual provisions, like any attempt to exclude the exception devoted to text and data mining, any exceptions relating to the exemption on judicial proceedings or legal advice, any exemptions relating to the work of galleries, libraries, archives, and museums. And other exceptions can also only be excluded by contract if the contract is negotiated in terms that are fair and reasonable. And that's interesting, because we're seeing that also develop in jurisdictions around the world, and very soon it will also be part of our law. Thanks. Of course, we bear in mind the new attribution right for creators, and just look at the different contexts in which it can occur. Sharing it online or on a social media platform. These are all instances where you know, people, in as much as the public will benefit from knowing who actually created the work, the author himself has a right to be named as author. And I think that is the upshot of this very significant moral right. We call it moral rights, but it comes under that category of copyright rights that arise by nature of by virtue of creativity and human authorship. It lasts for the entire term, and it can be asserted and enforced by the deceased author's estate as well. But also note the exceptions, as Trina alluded to. Next. I think we look at the copyright holistically. We consider increased rights. We appreciate the greater clarity, as well as the use of plain English. And you know, I mean, how many sections do you think the new Copyright Act has? 541. Okay, it's going to take some time to get through all of them. But you will see that I think we will develop our own doctrines of fair use. We will develop our own laws relating to the expanded categories of exception to infringement. And always keep in mind that rights and exceptions always have to occur hand in hand, which is what we allude to when we talk about the balance between the rights owner's interest in copyright with the user's interest. Thanks. And with that, I thank you for your attention. I end my presentation. I look forward to further discussions with the panel and all of you. Thank you.
Thanks so much for sharing, Trina and Stanley. Fascinating stuff, especially that big red bus case. Now that we're more aware of our legal rights and responsibilities, let's see how we can apply some of these to some common case scenarios. Let's invite Patrick back for these discussions. We're just going to have one case study and then we're going to switch into our Q&A, okay? Case study 1. Evelyn is a popular artist. She paints for a living. Her paintings include that of individuals, historic sites and nature, for example, lakes, mountains and forests. She understands that under the new Copyright Act, that if her work is reproduced, she must be identified. As her paintings are so popular, many have reproduced them without attributing her properly. I've got a quick question for Trina first. What can Evelyn do? What should she do to protect her rights? Can she enforce this against multiple parties in a cost-efficient and expeditious way?
Thanks, Kay, for the question. And actually, unfortunately, this kind of scenario is quite common. In order to answer what rights she has, how can she assert them, we really had to break it down piece by piece as to each painting that was reproduced. Remember I said earlier that every piece of work is independently protected. So yes, every time she sees a painting that is reproduced without her permission, she needs to first consider, does the copyright in the painting belong to her? Because there might have been pieces whereby she sold the artwork away. But if you sell the artwork, you're only selling the physical property, right? But you may still retain the copyright. But there may be instances where it could be a commissioned work by a company and the company took the copyright as well. I mean, they bought over the copyright. So the first most obvious claim she could think of is, oh, they've infringed my copyright. But it's not a general statement that she can say. She really has to look at each piece of painting that was reproduced. Does she retain the copyright in it? And if she does, then of course, she has a claim for such unauthorized reproduction. Now, separately from this, as similar to the example I gave for the illustrator, even if for that particular painting, she does not own the copyright anymore, she still has a right to be identified as a painter. So another separate right that she can consider. Now, in terms of asserting these rights and enforcing it, it doesn't mean she has to immediately start a court proceeding, go to the high court and spend thousands of dollars engaging a lawyer. It sometimes can start off simply by sending a written demand, what we call a cease and desist letter, to the person who has infringed her rights to say, please stop, take down the painting, or, hey, I'm glad you like my painting, but I'm the painter, I'm the artist, and you have the right to credit me, and then take it from there. We find from experience that quite a lot of matters can be settled by private negotiation. Now, of course, if she's going to claim compensation, she has to prove that she has suffered a loss. So let's say Evelyn is someone who licenses her paintings, right? She licenses to people who want to print them on marks or on postcards, or so she has a business for that. Then she can also think about monetary compensation. Now, she obviously the starting point is to get assistance of an IP lawyer. As Stanley was saying, a lot of this you kind of need a lawyer to help you navigate. Now, again, as I said, it doesn't mean you have to immediately be out of pocket by too much. As a starting point, if you're not sure where to start, how to start, you could actually apply to IPOS to attend the IPOS. We have this IP legal clinics. Basically, it's available to Singapore citizens, Singapore residents, and Singapore registered businesses, whereby you pay for a 45-minute session with a lawyer from a panel, but it's reimbursed. The fee you pay is reimbursed by IPOS, and these sessions are available for individuals and businesses who want to know how to protect and enforce their IP rights when there's an infringement. So that could be a good starting point for Evelyn. I hope that answers your question.
Super, thank you. And for question for Stanley, does the right of attribution apply to those who are based overseas, though, especially in this digital era? Did they also have to credit Evelyn for her work?
I think if you have a basis for enforcing copyright in Singapore, and there are connecting factors that apply, and also international treaties that give and allow a work to enjoy copyright protection under Singapore law, if that is the starting point, then yes, the right of attribution will apply because that's part of Singapore law now. So my short answer is yes. The question is whether you can actually enforce against that entity if it's a foreign party, or if it's party in jurisdiction. You can certainly take advice on that. But as long as the copyright can be said to apply that work, even though it's created overseas, I think the right of attribution would also apply.
Excellent, thank you. But what about, would your analysis change if Evelyn had actually set up a channel on YouTube, for example, doing painting tutorials that obviously couldn't be accessed by anybody, and then somebody else then went and replicated those similar paintings subsequently? What happens there?
Yeah, I think it's important to sit Evelyn down and to advise her that, look, you've got to decide what you're upset about first, right? The first thing you're upset with is the numerous reproductions that have been made of your work. So let's go through each of them. And it may very well be that you will need to surface this to YouTube or any social media site. Many of these platforms have their own grievance procedure now, which will allow you to basically lodge a complaint of copyright infringement. So that would be the first point, I think. And to be honest, with illicit and unlawful copies, your first point of advice to the client, I would suggest, may not be, well, insisting on your right of attribution. I think you've got to get unauthorized copies out of there first. And if, say, you come to an arrangement where you arrive at a settlement with another party, where you license the artistic copyright to reproduce 1 or 2 or 3 prints of the work, that would be the time I would bring in the discussion on attribution. But if my mission is to stop illicit copies, and don't forget that under our Copyright Act, reproductions can also take the form of 3-dimensional reproductions taken of 2D works and 2-dimensional reproductions taken of 3D works. I want to advise that we stop and control the copies under unlawful distribution first. Hope that answers the question.
Thank you very much. Yes, absolutely. And then over to Patrick. Is there any help from NTUC for creatives who find themselves in this situation and need to protect the rights to their work?
Yeah, thanks, Kay, and thanks everyone for having me on the panel. It's such a privilege to have Stanley here with us, who is the leading practitioner in this space, and of course, IPOS lead Trina, who is behind all these amendments. In fact, before I give some practical handles, I thought to share a bit about our journey here. In fact, why both Law Society Pro Bono Services Office and the Labour Movement has been partnering in this LawWorks endeavor is also because I think in this space, a number of freelance professionals, i.e. Freelance or gig workers, which is commonly used term, is a growing space. I mean, today, as we are talking, there are about 200,000 of you out there. And in particular, in the creative space, more than 30,000. And therefore, NTUC and Labour Movement is therefore, really rolling out our sleeves and really getting onto the ground and hearing out issues and concerns, including in the creative space, particularly the Copyright Act. And Trina and her team at IPOS will fondly recall, 7-8 years back, we had a focus group session. And in fact, in the last 7-8 years, we have lots of focus group discussions and sessions as we prepare to promulgate the changes. And I'm glad to see the fruition of some of the feedback from the ground. And this nicely segues to share some of the developments in this space, particularly in the help and redress. I think Stanley and Trina aptly gave all the various civil, legal, as well as well, in some ways also some practical pointers for all of you. But I think the bottom line, in the labor movement, we have set up a unit called the Unit for Freelance and Self-Employed, UFSC for short. In fact, we have started work in this space more than 5 years already. And we have made some inroads in certain spaces, particularly in the creative sector. Therefore, I wanted to use this opportunity to highlight some of the things that have been developed in the past couple of years, including, for example, 2 tripartite standards that came out. One for in managing self-employed persons or in transacting in self-employed persons, and another tripartite standards, not law but standards, which specific caters to media freelancers. I mean, the details essentially focus on payment, late payment, non-payment, and indirectly also covers issues of copyright in the sense of legal rights. So do look up for all these resources. In fact, this evening, as part of the run-up to today's session, we have also posted a QR code earlier on, and we'll endeavor to put it up again for you to download through Google Docs. So thanks to the PBSO team for preparing the Google Docs document, and where you can access many of these resources. So in it, well, later I'll touch a bit more on the resources available. But essentially, what we hope through the labor movement is to encourage each and every one of you, well, as a practical self-help, to band together. In fact, I'm happy to share that we've started forming, or should I say, form an association called VICPA. VICPA stands for Visual Audio Creative Content Professionals Association. Quite a mouthful, but essentially we are bringing a lot of the creatives together. In fact, not too long ago, last month actually, I met up with many of the leaders in this VICPA, and therefore we hope all of you, particularly, I see from the questions that are coming in, many of you may be content creators, maybe in the creative sector, or even adult educators. So we have actually formed various chapters, adult educators or trainers with the Education Services Union. We have coaches and instructors who do up training software, training materials, lecture materials. We also have photographers, script writers, etc., etc., all within this freelance and self-employed family. So I think unity is strength, and therefore I really appeal to all of you out there, be part of this community and these various associations, because I think some of these issues, well, you can take it legally or through the civil courts, but I think it's important to band together, because some of these issues may concern industry and dealing with different sectors, for example, like the public sector and different agencies. So I think it's good that we come together to overcome some of these roadblocks.
Hugely helpful. Thank you so much. That's brilliant. We've got about 20 minutes left, so I'd love to dive into our Q&A section. We have talked a lot about photographers, so perhaps we can switch over to perhaps some musicians. I've got a question here that says, say, for example, a marketing agency commissions the production of video that features a performance by a music group comprised of freelance musicians engaged by that music group. If the video is uploaded online publicly, is the marketing agency required to identify only the music group or each of the freelance musicians as well? Trina, would you like to take that one?
Sure. So basically, the law actually provides that you have to check in with the author how they want to be identified. So in the case of this kind of joint performance, right, if it is sufficient if they are found to be identified as a group. Yeah.
Mm-hmm. Great, thank you. But sticking on this kind of music topic, in the creation of an audio recording of a performance, does the new Act stipulate that the recording engineer owns the recording by default? Obviously, given that under the new Act, a photographer owns the copyright of a photo taken the photographer by default. So
maybe I'll take that. There is no change in who is the creator of a sound recording. The creator of the sound recording under the old Act, under the new Act, is still the maker. And the maker is the person who owns the first record that embodies the sounds, the person who owns. So it's usually, it's basically the production, the producer of the record, not your sound engineer.
Wow, excellent. Thank you so much. As we are living in such a time of where we're really using a lot of social media as well, I'm going to flick over to social media. So there's a question here about social media platforms like Facebook. Many people may share a photo taken by a creator and or an owner and on their own page, and they're going to share that with another page or a profile. Who's giving consent to do that? Is it Facebook? What's the rights of attribution there?
Okay, I guess I'll take that again also. Yeah, because it's a new right, and we are still, you know, I know a lot of people are trying to understand it. As I said, the right of attribution is personal to the creator. He doesn't assign it to Facebook because he allows people to post it up. So the person who uploads it is the person who is using it publicly, right? Is communicating the work to the public, is publishing the work. So he needs to get permission to, not get permission, he needs to attribute the photographer. It's a separate issue from copyright infringement. But if we're just talking about attribution, it's not Facebook who gives consent to say, oh, you don't need to, it's not Facebook who says you don't need to identify the photographer. It's the photographer himself who has to say that.
And then going back to what you were saying before about, you know, you need to kind of prove that you've suffered that loss as well, right? Yes. So how do you go about doing that?
Well, I mean, Stanley, feel free to jump in because this is, you know, about damage, but like, you have to show that because the person didn't attribute you, you suffered maybe a monetary loss. It need not be a current loss, but it could be a future loss as long as it's a reasonable consequence. So the case study you had, if Evelyn has a licensing business where she licenses her paintings, just reproducing it, but getting permission, but attributing to her in a way is opportunity cost. And well, I'll leave it to Stanley to confirm, but potentially that there should be some claim for damages there.
I think damages would certainly be something for investigation, but I think the primary, how do you deal with a breach of the attribution right? If you breach the attribution right, it's in our act. I mean, the way I would interpret it, it's like a breach of statutory duty. A statutory duty is breached, so you have an injunctive remedy. So the first thing you want to do is to assert the right and insist on accreditation. So I think that would always be the first point, and that's a general rule that we would apply to most IP infringements. That the whole point of the exercise actually is to stop the defendant from doing what they're doing. And then having done that, then you quantify the losses that have been sustained because of the breach. Sometimes it comes together. Other times, some clients are quite prepared to say, well, we just want the accreditation because I'm not in a position where I can measure economic harm directly. But what has been infringed are rights that I'm given by statute. So I think that's interesting. And the other point is, you know, to go back to your sound recording example, very important that the sound recording producer is not an author. The great thing about the Act, it draws a distinction between authorial works and what we call the controllers of the economic rights, in the sense that they produce and take your works to market, but every sound recording starts with a musical composition. That's a musical work. That's basically controlled by someone who's an author and will hopefully join. Patrick, what's the name of the society you just, which the acronym slips my mind again?
It's VICPA. VICPA.
Yeah, so VICPA, right, is definitely that kind of grouping you want to be part of. Because what we would like to see is the VICPAs and similar collections of creators coming together to actually basically roll out standard terms for the exploitation of their works. And that will make our job as practitioners a lot easier as well, because when we see that, we can then calibrate the terms to the harm that can basically occasion from the breach, you see. So I think, you know, just to give another reason, apart from coming together and expressing strength and unity, that strength is also expressed through standardization and terms for engagement, and everybody will be much more informed going forward.
Yeah, no, I can't emphasize more. You know, Stanley, you're absolutely right on point. That we notice oftentimes in some of these more acrimonious disputes in intellectual property, particularly in copyright, is you have the freelance professional, the creator, and he's all alone. And he's at the, he's at the wit's end, and then he's trying to enforce his rights. He's trying to look around and ask around. And therefore, that's why we created VICPA and band everyone together. Well, not just in the acting space, but in the photography space and in various spaces, music creation spaces. Because I think you're right, industry benchmarks and standards are very, very important. In fact, that's one of the impetus behind us doing up the tripartite standards, because we're quite worried about non-payment, payment, late payments, and some of the other rights which freelance professionals should have. And therefore, these two sets of tripartite standards, which the public sector has put their heads forward and say, we will abide by those standards. But I think I can't emphasize more the importance of coming together, because particularly having we deal with large organizations, agencies, even government agencies, one by one and in various ministries. I think that's something which we talked about quite a bit when the Act went for second reading. How can we overcome that? It's not going to be easy. Speaking on behalf of Trina, you can't expect IPOS to change the entire environment overnight. But I think it's through banding together is to bring some of these important industry standards and practices to light and get buying in, especially for buyers and users of creative works.
Excellent.
Yeah, and I think through that you also see how intermediaries like social media platforms will also come to recognize on the sort of insistence on rights that are advanced by different groupings of creators, and keep that in mind because when you upload something onto Facebook, you're basically giving a very extensive license to Facebook to use your content, not own, but to use your content. They can do onward sharing and monetize, and that is another big landscape. But you will see increasingly these calibrations taking place between the market, the rights owners, and the users and the intermediaries. So I think this is an excellent effort to bring that about.
So I add that caution to everyone. As you know, now we have a lot of social media channels and spaces and various platforms and vehicles. Please read the fine print. I think all of us have a tendency, me inclusive, sometimes you just post pictures and then without reading the exact terms and conditions. So if you do post some of your nicer pictures or your creations, which you hope perhaps maybe in the near future you want to monetize, do it with care and caution. And in whatever platform, it could be a music created and posted on YouTube. I know, yes, some of you may want to get the views, get the clicks, get the eyeballs, but please read the fine print, because you may be well signing, licensing, or even swearing your rights away.
Excellent, thank you so much. So we've covered quite a lot of music, we've talked about photography, but I've got quite an interesting question from the literary world. So for the new Copyright Act changes, when it's going to start taking into effect towards the end of November, as a work can be created over a period of time, do we consider it to apply as long as the work is completed after the Act takes effect, notwithstanding that the process of actually creating the work started beforehand? Trina, would you like to take that one?
As I said earlier, we are looking as to when the work was created when we talk about infringement of that work. So I was thinking about this question. So when you write an article, there are many drafts of the article. Each draft is actually a separate copyright work, and each draft could be separately infringed. But if you want to talk about unauthorized reproduction of the article, you're looking at a final completed piece. So when was that created? Before or after the Act came into force? I mean, practically that's how you would look at it. Unless for some reason somebody reproduced a draft, right? And that to you is significant enough to go after that person, then you look at when it came to force. But typically we look at the final completed work. It's a very practical, it's more, I'm talking very technically here, but if you look at practicality, what do you want to sue for infringement for? Think, what is the draft? What is the version of the work that has been infringed? And then you have to see when it was created.
Excellent, thank you.
And the thing that I would add to that also, if you look at the new Act, there's a general encouragement to publish the work as well. And that's useful because in the old days, when you didn't publish a work, basically you could potentially enjoy eternal copyright protection, which is interesting. But I think the new act, and if you look at the provisions, it forces us to actually advise clients get published, and you're most likely to publish the final version of the work. Nobody publishes a work in progress. So that's another point of reference, which I think will be useful.
Yeah, but I think I must add in here that the whole spectrum of copyright, or like in the words of Stanley, more than 500 sections of the Copyright Act may be quite indigestible for many of you tuning in. I know many of you are lay persons trying to try to navigate your way through this tough spot. But rest assured, I think in case you're not aware, earlier on you saw the QR codes, and please do download the resources. Even myself, I do access our IPOS website and the whole plethora resources there to give you the 101s to copyright. And I know some of you have posed questions on beyond copyright. What about trademark, patents, personal data? In fact, all these are actually available online, to the resources which IPOS has so kindly put in a very digestible format. And over and above that, in fact, she shared about the IPOS Legal Clinic as a result of this partnership in LawWorks and between NTUC and the Law Society Pro Bono Services Office. We've actually come up with a series of resources. I call it the 3-piece meal. So today's legal primer is the first piece. Second is, of course, the monthly legal clinics, which we do. And thirdly is actually a series, what we call the pocket series. In fact, this evening, I wanted to use this opportunity, since I know there's a couple of minutes more to buy some time to share that we come up with the latest copy of I Want to Be a Freelance Professional, fresh off the print. And we are giving this copy to each and every one of you, a PDF copy. So do scan the QR code that you see on your screen, and you can download this PDF copy exclusive to you. We have not posted and circulated it yet. So tonight's the very first minute where we are launching this updated version, which in its first form was created 7-8 years back. And now we have incorporated some of the details that we have shared, including some of the alternative dispute resolution methods, how to navigate, particularly if you are a freelance professional, and many other areas beyond copyright alone. And also we gave some details and some context on VICPA and the various associations that look after the various segments of the freelance professional groups.
Thank you so much. Those resources sound fantastic. I think I've probably got about time for one more, but I'm going to kind of put them together because there's a little set of questions from the kind of education world. So first part is, can we use logos, images, illustration for educational discussion purposes on digital platforms, for example, social media, as long as we use attribution where appropriate? But also then kind of semi-linked to that education world, can a trainer's PowerPoint presentation slides be protected under the Copyright Act? Trina, would you dive in there?
I would like to dive in because I think this is a nice way you had of putting together all the questions of education, and to tell everybody about this new education exception that was alluded to. Basically, we are looking at a purpose-based exception, but it's for non-profit educational institutions, largely your MOE schools, that can use freely available material on the internet. That means it's not hidden behind a paywall, and they have to use it for the teaching, or either giving instruction or receiving instruction, and there are certain conditions to be met. You must cite the internet source, and when you access it, you must give sufficient acknowledgement of the author and a description of the work. It's different from the right of attribution. This is the condition for the exception to apply. Now, if you're going to disseminate it to your students, or your students are going to disseminate it to their fellow classmates or a teacher online, it must only be done on MOE's student learning space, which is a secure intranet, or on the school's network that it's not publicly available to the rest. Right. So the question asked was, if I just take logos and all that and I do it for a non-commercial educational discussion on Facebook, you cannot avail yourself of this educational exception. Then you have to look at fair use, what Stanley was talking about earlier. You see, what is the purpose of the discussion? Are you taking away a market substitute? And some creators think that if they put on their blog or on their video or their works that you put there. You may not use it for any purpose, including educational purposes, without getting consent. It doesn't actually work for this educational exception. The primary basis of the educational exception was to make it easier, because everything is online now, make it easier for schools to get resources, but for teaching. So it falls within that group that Stanley was talking about, how certain contractual restrictions do not apply. So if it's a non-negotiable contractual term, like in this case, a website terms and condition, or you may not use, it is invalid and you can still use it for the educational exception if you met the previous conditions. Yeah. So thanks for letting me share about that.
And Trina, I want to take off from this point, because I know many of you tuning in are in private education institutions and organizations, and this exception does not apply to non-public. So if you're private, commercial, or for-profit, then I think Trina was quite clear that it's specifically for usually the public sector kind of educational institutions.
The one thing I would add, if I may, to that also is that when you're using logos, just bear in mind that you also may potentially deal with trademarks, and trademarks and logos can be protected either as trademarks. They can also be concurrently protected as artistic works. So in relation to artistic works, I think what Trina and Patrick have said is absolutely right. For trademarks, you want to ask yourself, well, are you making a trademark use of this device when you're teaching? And most of the time, I think the answer will be no, because you're not using it to as an indicator of origin or any other function that would that may put you into difficulty with the Trademarks Act. But just notice that if you want to use a McDonald's sign, for example, in your teaching materials, just be very clear what the context is and the purpose, because it may not be a trademark use, but at least you need to tick that box. So I think that's a very good illustration of how other rights can come into play as well, in addition to copyright.
Thank you so much. We are actually almost at the top of the hour. So I'd like to invite each of you just to leave us with one key takeaway. Trina, do you want to go first?
Okay. I remember Kay, when we discussed, he said, let's prepare, we should think of something. But actually look at the questions, one key takeaway is, I'm going to emphasize again, copyright ownership is separate from your right attribution. If you want to use somebody's work, firstly, you do need to get permission to use it, to reproduce it. Separately, you need to think whether you should credit the creator, because sometimes the copyright owner is not the creator. So be very clear, these are two separate rights, and don't conflate them thinking, oh, I attributed the creator, so therefore I can use the work. You need permission to use it. So that's my key takeaway for everybody here.
Thank you. Stanley?
I think freelancers are tremendously important in our corporate landscape, because everything starts from created work, and that's why authors matter. So I would strongly encourage, please follow up with everything that Patrick's announced, because potentially these organizations can be much more influential unto themselves, and even dictate the rights that they would, how they want their rights commercialized and administered. So I think if you come together in strength of numbers, that to me will be a great space to be in. And the Copyright Act must not be viewed as a series of complicated sections. It ultimately should give rise to a larger conversation between all the stakeholders to find an equilibrium with which they can deal with, you see. And that is, I think, to me, a very much wanted prize at the end of this.
Thank you. Patrick?
Yeah, I just, I'm glad to share that there's a lot of tripartite as well as national attention placed on the gig workers and, of course, freelance professionals. I think that's, you can see, from the developments of tripartite standards. And, of course, recently there's been announced the formation of a work group to look into some of the initiatives to support freelance professionals in various aspects where they are vulnerable, where they we need to create a more fair and level playing field for each and every one of you. So that's one key development. But I think on a personal level, I would advocate the ABC. Access the resources. You can see on the screen it's QR codes, and there are so much resources, compendium resources, whether it's copyright, whether it's contractual claims. I think they're all available, and of course the Pocket series, do have a look at it nicely. I think you can read front to back in less than 20 minutes. So do access it, access the resources. B is band together. I shared about VICPA, and not just VICPA, but adult educators, coaches, instructors, in various fields. So we are actually trying to get people to band together to overcome some of these obstacles, whether from a regulatory perspective or a policy perspective or advocacy perspective. And finally, C, the ABC ends off with a C, is consult. Consult a professional. I think there are many leading professionals, including Stanley, and of course IPOS has availed a whole series of resources and legal clinics as well, specifically tailored to IP. So do consult, and of course PBSO together with NTUC is also our own legal clinics. That's also another avenue where you can consult, and again come together, and hopefully we can overcome some of these challenges and issues which we have seen, particularly during the Q&A this evening.
Thank you so much. Before we end the webinar, we do have two very exciting webinars coming up as part of the Law Awareness Weeks at CDC 2021. If you found today's webinar beneficial, there will be a webinar called My Idea, My Property, happening tomorrow at 7 p.m. Do you know friends who are independent content producers? Are they constantly worried that someone might steal their work and profit off it? Join as moderator Abigail Tan and speakers Gretchen Su and Trina Ha as they discuss your legal rights and remedies against such infringements and how you can take steps to protect your intellectual property. Another webinar is Am I Still Employable? Navigating Your Job from Pandemic to Endemic, happening next Friday at 7 p.m. This pandemic has affected everyone, but the effects are disproportionately borne by vulnerable workers. The job market is at a very different level now. Given the current economic uncertainty, many employees find themselves already facing termination or even retrenchment as businesses struggle to stay relevant and afloat. Join moderator Wang Lingsheng and speakers Patrick Tay and To Wei Yi as they share on the schemes and labour laws available in this endemic phase and what you can do to protect and also uplift yourself. You can scan the QR code or visit www.cdc.gov.sg/Law Awareness Weeks to register for the webinars. Thank you for spending your Thursday evening with us. On behalf of the organisers, we would like to thank our speakers as well for their time and generosity. We hope you found our webinar on the new Copyright Act 2021 useful. Once you leave today's webinar, you will receive a survey on your browser, and we will really appreciate your feedback on today's session. Your feedback will help us to make future webinars more relevant and useful to you. Thank you very much, Trina, Stanley, and Patrick, for spending the evening with us. On behalf of the Law Society Pro Bono Services, thank you everyone for joining us today. Good evening.